that it is an individual right to bear arms.
The Second Amendment gives the individual right to keep and bear arms.
But today's bill will do nothing but disarm law-abiding citizens. Congress has tried this before.
The HERE Act would prohibit the sale, transfer, production, and possession of gun silencers.
Texas Case Update. All right, folks, let's dive into the latest episode of the Texas Suppressor Freedom Case saga. You won't believe the twists and turns this legal roller coaster has taken. Buckle up. So picture this. The Lone Star State taking a stand against the ATF's suppressor regulations. It's like a Wild West showdown, but in the courtroom. The Texas Suppressor Freedom case was making waves, aiming to challenge the National Firearms Act and ATF rules on suppressors. Now here's the plot twist. The Supreme Court has entered the chat. That's right, the big shots are getting involved. It's like having the heavyweight champion step into the ring during a backyard brawl. The Supreme Court's nod to the ATF stance on suppressors has sent shockwaves through the legal landscape. The Texas case, known as Paxton versus ATF, has been grinding its gears in the lower courts. Things were getting spicy with arguments about standing, whether the individual plaintiffs and the state of Texas had a legitimate horse in this legal race. And then, bam! The district court dropped the gavel, dismissing the case like a hot potato. Why? Lack of standing, they said.
But not even the United States military relies on silencers to protect our soldiers' hearing.
The government already bans automatic weapons. Why? Because they have no place in our communities.
The Second Amendment says the right to keep and bear arms shall not be infringed.
The court ruled that neither the individual gun owners nor the state of Texas had shown enough skin in the game to challenge the ATF's suppressor regulations. But wait, the Lone Star isn't one to back down easily. Texas slapped an appeal on the table, taking the whole shebang to the Fifth Circuit Court of Appeals. It's like the underdog refusing to stay down after a knockdown. Texas argued that this case wasn't just about suppressors, it was about fundamental constitutional rights. In the legal world, this is like the Super Bowl of Second Amendment battles. The outcome could set a precedent, influencing how future cases tackle gun rights and regulations. Dismissal by lower court. All right, let's break down the courtroom drama in the Texas Suppressor Freedom case, the one where the district court slammed the door shut, dismissing the whole shebang. Get ready for the inside scoop. So there we were, in the heart of legal tussles, where the district court took center stage. Picture a judge with a gavel making decisions that could sway the entire plot. And guess what? The judge dropped a shocker. They dismissed the case like it was yesterday's news. Now you might be wondering, why the dismissal? Well, it all comes down to a little thing called standing. The court wasn't convinced that the individual plaintiffs, those brave gun owners taking on the ATF, and the state of Texas had enough skin in the game to play ball. Standing, in legal jargon, means you gotta have a horse in the race, a real tangible interest in the outcome. The district court argued that the individual gun owners failed to show a concrete injury. It's like saying you can't cry foul unless you've got a real bruise to show. The judge did acknowledge that, sure, the government has a history of going after folks for illegal possession of unregistered silencers. But here's the catch. The individual plaintiffs didn't bring any evidence to the table that they actually had illegal silencers or had done anything that might get them in trouble.
NRA wants you to believe that silencers are necessary to protect the hearing of gun owners.
1933, quote, the right of the citizens to keep and bear arms has justly been considered as the palladium of the liberties of a republic.
It's like saying you can't fight a speeding ticket if you weren't caught speeding in the first place. Now let's talk Texas. The state stepped into the ring saying, hey, we're here to protect our citizens. But the district court wasn't having it. They argued that Texas couldn't stand in for its residents in this legal showdown. It's like telling a friend, you can't fight my battles for me, you've got to fight your own. In a nutshell, the district court hit the gavel and said, case dismissed. Why? Because the individual gun owners didn't show enough proof of harm, and Texas couldn't be the legal knight in shining armor for its people. Will Texas make a comeback? Only time, and maybe a higher court, will tell. Paxton versus ATF. Let's dive into the legal arena of Paxton versus ATF. where the state of Texas and the ATF squared off in a battle over suppressor regulations. This legal clash revolved around Texas House Bill 957, a bold attempt by the Lone Star State to challenge the National Firearms Act and the ATF's authority regarding in-state-made suppressors. As the legal drama unfolded, the district court emerged as the pivotal stage for this legal showdown. The court, akin to a referee in this legal boxing ring, had the monumental task of deciding the fate of Paxton versus ATF. In a move that sent shockwaves through the case, the district court issued a decision. In essence, the district court dropped the hammer and dismissed the entire case. The reasoning behind this decision was primarily grounded in the concept of legal standing. The court argued that the individual plaintiffs, representing gun owners, failed to demonstrate a concrete and immediate injury. They couldn't show that they possessed illegal silencers or engaged in prohibited conduct that would warrant legal action.
The HERE Act would prohibit the sale, transfer, production, and possession of gun silencers.
But today's bill will do nothing but disarm law-abiding citizens. Congress has tried this before.
The court deemed that the state of Texas couldn't stand in for its residents in challenging federal regulations. It was a double whammy. Both individual gun owners and the state found themselves on the losing side due to the perceived lack of standing. With the district court's decision ringing in the legal arena, the case didn't fade into obscurity. Instead, it took the express route to the appeals process. Texas, unwilling to concede defeat, filed an appeal, propelling Paxton versus ATF to the Fifth Circuit Court of Appeals. The appeals process became the battleground for reconsidering the district court's decision and reigniting the flames of this legal clash. In summary, Paxton versus ATF is a legal saga characterized by Texas's defiance against federal suppressor regulations. The district court, acting as the initial arbiter, dismissed the case on grounds of standing, prompting an appeal to the Fifth Circuit Court of Appeals and ensuring that the legal showdown continued to capture attention and scrutiny. Fifth Circuit Court to review lawsuit. Currently, the legal roller coaster that is the Texas suppressor freedom case finds itself hurtling towards a significant juncture, the Fifth Circuit Court of Appeals. This higher court review has injected a new dose of anticipation into an already riveting legal drama. As things stand, the case is no longer confined to the lower district court. Instead, it has climbed the legal ladder, ascending to the Fifth Circuit Court of Appeals, a move that holds immense implications for the fate of the Texas suppressor challenge. The significance of the Fifth Circuit Court's involvement lies in its role as the arbiter of appeals. It's like the case just entered the majors after proving itself in the minors. This court has the power to reconsider, scrutinize, and potentially overturn the district court's decision, injecting a fresh perspective into the legal discourse. Why does it matter, you ask? Well, a higher court review implies that the legal arguments and constitutional considerations are about to undergo a more thorough examination. The Fifth Circuit Court is not just any court. It's a platform where the complex web of legal intricacies surrounding the Texas suppressor case can be untangled, and a new precedent might be set.
So you can't protect yourself with a 9mm. I guess according to Biden, only a 22 round ammunition would be sufficient.
The
That it
Second
is an
Amendment,
individual right
the
to bear
Second
arms.
Amendment gives the individual right to keep and bear arms.
This review also underscores the broader significance of the case within the legal landscape. The Fifth Circuit doesn't take up every case that comes its way. Its involvement signals that this isn't just your run-of-the-mill legal scuffle. It's a case that warrants careful consideration due to its potential impact on constitutional rights, particularly those related to the Second Amendment. In essence, the journey to the Fifth Circuit Court of Appeals transforms the Texas suppressor freedom case from a local legal skirmish to a nationally significant legal bout. The Fifth Circuit Court's review is not just a pit stop, it's a pivotal moment that could reshape the narrative and outcomes of this legal saga. Stay tuned as the drama unfolds in the hallowed halls of the Fifth Circuit Court of Appeals. ATF's argument. In the legal battleground of the Texas suppressor freedom case, the ATF has thrown down the gauntlet with a bold argument. They're claiming that suppressors are mere accessories, not worthy of the protections bestowed by the Second Amendment. It's a legal dance where the ATF is attempting to redefine the status of suppressors to justify their regulatory authority. To break it down, the ATF's core assertion is that suppressors shouldn't be considered bearable arms under the Second Amendment. Instead, they argue that these devices fall into the category of accessories, akin to add-ons or attachments, rather than fundamental components of firearms. In essence, the ATF contends that suppressors are like the sidekicks of the gun world, not entitled to the same constitutional protections. Now, let's delve into the meat of the ATF's arguments as laid out in their legal briefs. One key point they emphasize is the categorization of suppressors as accessories. They argue that because suppressors don't constitute bearable arms, laws regulating accessories don't necessarily infringe upon the Second Amendment. This stance hinges on the interpretation that the Second Amendment only extends protections to items that are considered essential components of firearms. In their legal jargon, the ATF further contends that the Second Amendment safeguards instruments typically possessed by law-abiding citizens for lawful purposes. Here, they're drawing a distinction between firearms, which they consider protected, and accessories, which they assert fall outside the scope of constitutional protection.
This bill, and it gets brushed aside, raised the age limit. Well, there are constitutional questions to that in the Fourth Circuit, Ninth Circuit, and other circuits.
The report, I believe, supported ATF's action in cataloging records to stop crime.
Supports a ban on the sale of assault weapons, which there's no such thing, and high-capacity magazines.
Another crucial argument put forth by the ATF is the assertion that suppressors, being accessories, don't inherently implicate Second Amendment protections. They claim that laws regulating accessories or attachments don't necessarily encroach upon the rights enshrined in the Second Amendment. In their eyes, a suppressor is more like a tool attached to a firearm rather than a fundamental element of the firearm itself. While the ATF regulates suppressors under the NFA as firearms in their own right, they're now arguing in court that, constitutionally speaking, suppressors are nothing more than accessories. In essence, the ATF's argument in the Texas suppressor freedom case boils down to a reinterpretation of suppressors as accessories, not bearable arms. It's a legal maneuver that challenges conventional wisdom and sets the stage for a broader debate on the constitutional status of firearm accessories. As this legal showdown unfolds, the outcome will undoubtedly shape the landscape of Second Amendment jurisprudence.
But at the crux of this is a bureaucrat making a unilateral decision to try to turn millions of Americans into felons.
Americans have the fundamental right to keep and bear arms that shall not be infringed.
Weapons and high-capacity magazines in 3 communities in 3 different states in our nation. Enough!
Constitutional importance of the case. Texas isn't backing down in the face of legal challenges. In the Texas suppressor freedom case, after the district court rang the dismissal bell, the Lone Star State decided to take the fight to a higher ground, the Fifth Circuit Court of Appeals. And they're not just appealing, they're bringing a constitutional artillery to the forefront, arguing that this case isn't just about suppressors, it's about fundamental constitutional rights. In their appeal to the Fifth Circuit, Texas makes a strong case for the exceptional constitutional importance of Paxton versus ATF. They argue that this legal battle goes beyond the intricacies of suppressor regulations. It delves into the heart of citizens' rights and the balance of power between state and federal authorities. One of the primary constitutional issues raised by Texas is the question of whether Texans have the standing to challenge the constitutionality of statutory requirements before applying for permission and paying the tax. In simpler terms, they're questioning whether citizens should be subjected to a potentially unconstitutional process before challenging it. It's a bold argument that seeks to address the rights of individuals before they're entangled in a bureaucratic web.
Under the new rule, the firearm owners will be required to obtain special registration, surrender or destroy their brace.
Gun violence in this country is an epidemic, and it's an international embarrassment.
Texas also raises the issue of whether the state itself has the standing to vindicate the quasi-sovereign interest in its citizens' health and safety. This brings the spotlight onto the broader question of states' rights and their authority to protect their residents from what they perceive as federal overreach. The appeal challenges the notion that Texas, as a state, can't stand up for its citizens in legal battles against the federal government. Furthermore, Texas pushes the Fifth Circuit to consider the broader implications of the case on constitutional grounds. They are essentially asking whether the citizens of Texas have the right to challenge the constitutionality of regulations before being subject to those regulations. It's a profound inquiry into the balance between individual freedoms and governmental authority. In essence, Texas is framing this appeal as a pivotal moment in the ongoing saga of constitutional interpretation. They're not just fighting for the right to make and use suppressors. They're fighting for the right to challenge regulations they deem unconstitutional before being subjected to them. The constitutional importance of this case transcends the specific issue of suppressors, making it a legal battleground for fundamental rights and the boundaries of governmental power. As the appeal unfolds, it will be a case to watch for anyone interested in the delicate dance between individual liberties and regulatory authority. ATF's response. In response to Texas's spirited appeal to the Fifth Circuit, the ATF has stepped into the legal ring, ready to defend its ground. The agency is not pulling any punches, urging the higher court to affirm the district court's dismissal in the Texas suppressor freedom case. Let's unravel the ATF's response and spotlight the key points they're throwing into the legal arena. Firstly, the ATF is making a peculiar argument about efficiency. They assert that the process to comply with the NFA requirements, the registration, taxation, and all that jazz, is a swift one. In fact, they suggest that it would have been more efficient for the individuals involved to simply go through the process rather than filing a lawsuit. It's an interesting angle, essentially contending that challenging potentially unconstitutional regulations takes longer than complying with them. Additionally, the ATF counters Texas constitutional arguments by emphasizing that the mere invocation of a constitutional right isn't sufficient to establish standing. They argue that there must be an imminent, non-speculative, and irreparable injury, and according to the ATF, the plaintiffs in this case failed to demonstrate such an injury. Essentially, they're pushing back against Texas's claim that the citizens and the state itself have a right to challenge the constitutionality of the regulations without first being subject to them. Furthermore, the ATF dives into the timeline, asserting that the average registration processing time is a mere 70 days or less. This, they claim, disputes the argument that the time involved in complying with NFA procedures is an injury in itself.
As of this morning, there have been 255 mass shooting incidents in America.
That there should be an assault weapons ban. I think it would have been up to the Ohio legislature.
It's a technical defense, attempting to diminish the significance of the time required for the regulatory process. One of the ATF's central arguments continues to be its stance that suppressors are accessories, not bearable arms, and thus not entitled to the protections of the Second Amendment. They assert that the Second Amendment's protection extends only to instruments that constitute bearable arms, and suppressors, in their view, fall outside this scope. It's a critical point, and the ATF is doubling down on its interpretation despite the potential contradiction with their own regulatory framework that designates suppressors as firearms under the NFA. Texas's stand. Texas isn't just waving the flag, it's laying down the legal gauntlet in the Texas suppressor freedom case. In their appeal to the Fifth Circuit, the Lone Star State is coming out swinging, challenging not only the regulatory framework, but also asserting its standing and the interests it seeks to safeguard. At the heart of Texas's legal thrust is a direct challenge to statutory requirements. They're not merely accepting the status quo, but questioning the constitutionality of requiring individuals to go through a potentially unconstitutional process before challenging it. In simpler terms, Texas is saying, why should we subject our citizens to a possibly flawed system before they have the chance to question its legitimacy? This argument strikes at the core of due process and the right to challenge the constitutionality of laws before being compelled to adhere to them.
I think you need to have weapons to take on the government You need F-15s and maybe some nuclear weapons.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
Texas isn't just throwing punches for its citizens, it's stepping into the legal ring on behalf of the state itself. Texas asserts its standing, its right to be a player in this legal showdown. The state is essentially saying, we have a stake in this game and we're not going to sit on the sidelines. Texas argues that it has a quasi-sovereign interest in the health and safety of its citizens. This challenges the notion that states can't stand in for their residents in legal battles against federal regulations, asserting that they have a vital role in protecting their citizens' rights and well-being. In essence, Texas is challenging not only the specific regulations, but also the procedural aspects of how these regulations are enforced. They're asserting the rights of both individuals and the state itself to question the constitutionality of laws before being subjected to them. It's a legal maneuver that aims to carve out a space for proactive challenges to potentially unconstitutional regulations, setting the stage for a broader discussion on due process and the balance of power between states and the federal government. As the legal saga unfolds, Texas's stand becomes a focal point in the intricate dance of constitutional interpretation and regulatory authority. Texas House Bill 957. To grasp the dynamics of the Texas suppressor freedom case, it's essential to delve into the background intricacies surrounding National Firearms Act regulations and the role played by Texas House Bill 957. The NFA, originating in 1934, laid down a comprehensive set of regulations governing specific firearms and accessories. Among the items falling within the NFA's ambit were suppressors, devices engineered to diminish the sound produced by firing a firearm. Crucially, the NFA categorized suppressors as firearms in their own right, bringing them under the jurisdiction of federal oversight. This classification subjected suppressors to a meticulous process involving registration, taxation, and stringent federal scrutiny. Navigating this regulatory landscape meant that individuals desiring ownership of a suppressor had to undergo thorough background checks, provide fingerprints, and pay a federal tax. The NFA essentially treated suppressors as controlled items, emphasizing federal control and oversight. Enter Texas House Bill 957, a legislative maneuver by the Lone Star State aimed at challenging the NFA regulations. Enacted in prior years, this bill sought to carve out an exemption from federal regulation for suppressors manufactured and retained exclusively within the state of Texas.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
We have the third highest gun-related injuries in the country, 90% higher.
The Second Amendment, from the day it was passed, limited the type of people who could own a gun and what type of weapon you could own.
The underlying logic was that if suppressors were produced and sold solely within Texas, they would be exempt from interstate commerce regulations and, consequently, fall outside the purview of federal oversight dictated by the NFA. However, the clash ensued when the ATF, affirming its authority, dispatched warning letters asserting that it retained control over these Texas-manufactured suppressors. The agency maintained that despite the state law, federal regulations under the NFA still applied, signaling a clear conflict between state and federal jurisdictions. This prompted Texas, along with individual plaintiffs, to mount a legal challenge against the ATF, leading to the Texas suppressor freedom case. The dispute hinges on the constitutional implications of federal regulations, the scope of state authority, and the rights of individuals to challenge potentially unconstitutional laws before being subjected to them. The lawsuit emerges as a battleground where the Lone Star State confronts federal regulations, asserting its right to shape firearm policies within its borders. The Texas suppressor freedom case isn't merely a legal skirmish over suppressors. It symbolizes a broader struggle over states' rights and individual liberties in the realm of firearm regulation. Fifth Circuit's role. The Texas suppressor freedom case isn't just a legal tussle confined to Lone Star borders. It reverberates in the broader arena of Second Amendment protections. At the heart of this legal saga is the fundamental question of whether suppressors, those devices designed to muffle the report of firearms, merit the constitutional shield of the Second Amendment.
Change a law. They are already used to breaking the law, and the people will still do it, will continue to do it.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
The role of the Fifth Circuit Court of Appeals in addressing this question holds significant implications for the landscape of firearm rights. In the ongoing legal bout, the Fifth Circuit finds itself in a pivotal position, serving as the referee tasked with determining the constitutional status of suppressors. That's all for this video, folks. See you next time.